Hello guys. Let's begin with chapter 3 of unit 2. Title is Sources of Law. Where does law come from? So you see, in the previous two chapters we saw what is law, then we saw types of law. Now we come on to law आया कहाँ से, ठीक है? Sources of law mean sources from where law or binding rules of human conduct originate. In other words, law is derived from sources. हर किसी का कोई ना कोई source होता है. Everybody has come from some or the other point. So has law. It has come from something. तो वो something क्या है जहाँ से law originate हुआ? That is nothing but sources of law. Jurists have different views on origin and sources as they have regarding definition of law. You see, there were various schools of law, and there was various thinking of those jurists and legal philosophers regarding what could be a proper definition of law. इसी वजह से आज तक कोई भी unanimous definition setup नहीं हो पाई. As the term law has several meanings, legal experts approach the sources of law from various angles. For instance, Austin considers sovereign as sources of law. ये हमने पहले चैप्टर में भी किया था, यूनिट 2 के पहले चैप्टर में. Austin was considering that law is something which has come from the sovereign society, while Savaney and Henry Manne consider custom as most important source of law. So these two, Savaney and Henry, said that whatever the customs or traditions of the place is, according to that, law comes out to be. Natural law school considers nature or God as the source of law, while theologians consider religious scripts as sources of law. Although there are various claims and counterclaims regarding the sources, it is true that in almost all societies, law has been derived from similar sources. So different people, according to their own thinking, there are different sources of law, but at some or the other point there are some similar cases in different societies from where law has emerged. Then classification of sources. Salmond, an English jurist, has classified sources of law into following categories: formal and material sources. Formal sources are those from which law derives its force and validity. Law enacted by state or sovereign falls into this category. Formal means which has been enacted by the legislature organ or by the government. So these are the sources from where law is derived as a, जैसे कोई डिपार्टमेंट से कोई चीज़ निकल रही हो, तो दैट इज़ फॉर्मल. Something which is officially valid sort of thing. So something which has emerged from the department or from the state, from the government, that fall under this category. Material sources is all about from where the laws are derived, all about the matter from where, customs, traditions, जो वहाँ के लोग फॉलो कर रहे हैं. कस्टम्स बहुत इन्फ्लुएंस करते हैं लॉ को. Customs and traditions or the culture is also a very important and very common source of law. So that is material source of law. Or other than these legislature matters, from wherever, from whichever custom or tradition which that place people are following, that is material sources of law. However, if you look around and examine contemporary legal systems, it may be seen that most legal systems are based on legislations. At same time, it is equally true that sometimes customs play a significant role. In some of the legal systems, court decisions are binding as law. So there are various situations in various countries or societies, and according to that, the laws vary. Somewhere parliament or the legislature are the law making bodies, और उन्हीं के जो laws हैं वो binding consider किए जाते हैं. At some places cultures or traditions से जो law emerge हुए हैं, that is the supreme law of that country. And at some places the court verdicts, जो judges decisions देते हैं, that is considered to be a proper binding law. On the basis of this, three major sources of law can be identified in any modern society: custom, judicial precedent, legislation. यही तीनों तो अभी हमने बोले ना. क्या बोला हमने? कोर्ट डिसीजंस विच आर बाइंडिंग, and it can be considered as a law. Then some legislations जो legislature बना रहा है, or sometimes the customs. Custom as a source of law. Custom to be valid must be observed continuously for a very long time without any interpretation. Further, a practice must be supported or not only for a very long time, but it must also be supported by opinion of general public and morality. However, every custom need not become law. हर चीज़ law नहीं हो सकती, but out of some customs law can emerge, and for that custom to become a law it must be that वो valid हो. ऐसा कुछ ना हो जो मतलब if somebody is ऐसा कोई custom है कि आपको किसी को मारना है and then you can only live a life, तो और then only you can marry, किसी को मार के किसी की बलि चढ़ा के जो पहले होता था, सो दैट नहीं, दैट इज़ नॉट अ वैलिड कस्टम. ठीक है, कोई गलत काम करके उस लॉ को बनाना, कोई गलत काम जिसमें हो रहा हो, दैट कैन नॉट बी मेड एज अ लॉ, चाहे वो कस्टम ही क्यों ना हो. सो कस्टम शुड बी वैलिड एंड इट शुड बी प्रैक्टिस्ड फॉर अ वेरी लॉन्ग टाइम कंटिन्यूसली विदाउट एनी ब्रेक. एक दिन, एक साल का भी ब्रेक नहीं होना चाहिए. कंटिन्यूसली उसको बहुत ज़्यादा समय तक के लिए उस कस्टम का प्रैक्टिस में होना ज़रूरी है, उसको फॉलो करना ज़रूरी है. इट मस्ट बी फॉलोड फॉर अ वेरी लॉन्ग टाइम कंटिन्यूसली विदाउट एनी सॉर्ट ऑफ ब्रेक. And it also must has the opinion, the wishes of the general public कि हाँ this custom is good and we are following it from this time without any break. तो it should have the opinion or the will of the general public also. सिर्फ practice ज़रूरी नहीं है, opinion and will of the general public should also be, support of the general public should also be in favor of that custom. Hindu Marriages Act 1955 prohibits marriages which are within the prohibited degrees of relationship. However, Act still permits marriages within the So what is prohibited degree of relationship? See, if there are two generations and like जो there are two generations, ठीक है, parallel generation है, a father gave birth to two sons, then this son gave birth to a daughter and a son, this gave birth to two daughters. Okay, now you see this son cannot marry this daughter, this son cannot marry this daughter, this son cannot marry this daughter. So this is prohibited degree of relationship in Hindu Marriages Act, according to which same generation people cannot marry. And also it is not only till same generation, it is still 5 and 6 generation of maternal and paternal families. So that's how the case is. पूरी तरीके से prohibited नहीं है. Within a certain community caste system भी valid है, but the thing is that सेम जनरेशन पीपल, जो चाचा ताऊ और ये सब आपस में बच्चे इनके शादी नहीं कर सकते इन हिंदूज. Custom can simply be explained as those long established practices or unwritten rules. Obviously कोई भी custom है वो written नहीं होता, these are unwritten, and if they are long established practiced without any rule, then that can be taken as a law. In ancient societies, custom was considered as one of the most important sources of law. हमारे रीति रिवाज ये कहते हैं, तो पहले के ज़माने में रीति रिवाज का बहुत ज़्यादा इम्पोर्टेंस था. In fact, it was considered as a real source of law. With passage of time, advent of modern civilization, importance of custom as a source of law diminished, and other sources such as judicial precedents, legislation gained importance. So as we came into the modern civilization, कस्टम ट्रेडिशंस की इम्पोर्टेंस कम होती चली गई, और जुडिशल प्रेसिडेंट्स, जुडिशल डिसीजंस, लेजिस्लेचर जो फ्रेम कर रहा है लॉ या जो कॉन्स्टिट्यूशन है, उन सब की इम्पोर्टेंस बढ़ गई. Can custom be a law? There is no doubt about fact that custom is an important source of law. Broadly, there are two views which prevail in this regard on whether custom is law. Jurists such as Austin opposed custom because it did not originate from will of sovereign. Austin said that law is something which will originate from the sovereign. And customs weren't something which is originating from the sovereign. So Austin was against this. Jurists like Savane consider custom as main source of law. According to him, real source of law is will of people and not will of sovereign. और will of people क्या है? Custom है. People are wishing that it should be implemented, and they are accepting that also with full hearts. The will of people has always been reflected in custom and traditions of society. That's why they are following it from a certain long period of time. Saptapati Gamanam. Now, this is something which is a very important practice which is going on from time immemorial, and it is also given in the Hindu Marriages Act of 1955. Saptapati Gamanam is basically जो हिंदी में कहते हैं 7 फेरे, that is 7 steps. It is a custom only which has now been under an act and it has become a law. It is the most important part of a marriage ceremony. The word means 7 steps. After tying the Mangal Sutra, newlywed couple takes 7 steps around the holy fire, which is called Saptapadi. Customary practice of Saptapadi has been incorporated in Section 7 of Hindu Marriages Act. Now, kinds of customs. Customs without sanction. These are non-obligatory in nature and are followed because of public opinion. They are not written somewhere. They are just followed because it was followed from a very long time, and people का opinion है, people का will है उसकी तरफ. They are in favor. They are supporting that custom, so they are following it from a certain long period of time. They are not being sanctioned by the government, or they are nowhere mentioned in any rule book. Customs with sanction, these are binding in nature. ये सबको follow करने होते हैं and are enforced by the state. These custom can be divided into following categories: legal custom and conventional custom. Legal custom is whose authority is absolute. It possesses force of law. It is recognized and enforced by courts. Legal custom may be further classified into 2 types: general and local. So legal custom, as the word itself suggests, a custom which is authorized. Authority absolute है, which is established and recognized by the courts. General customs prevail throughout the territory. General होते हैं, for everybody it is applicable. Local customs to a certain territory or to a certain part of the country. Conventional customs are binding on parties to an agreement. When 2 or more persons enter into an agreement related to a trade, it is presumed in law that they make the contract in accordance with established convention or usage of that trade, according to what all the conventions and terms and conditions in that trade is. So, अगर उस trade में 2 people are entering into an agreement, so it is assumed as per law that if they are entering into an agreement or a contract, then that would be according to these established conventions. For instance, an agreement between landlord and tenant regarding payment of rent will be governed by convention prevailing in this regard. तो इसके लिए जो conventions होंगी उनको follow करते हुए ये tenant और landlord का relationship चलेगा. ठीक है? Now, essentials of a valid custom. That I'm gonna take in next video.